Mr. Speaker, are you kidding me? Who the hell is running this place? A 5-year reauthorization, 5 years, and Republicans threw it together on the back of a napkin in a back room in the middle of the night. There have been real bipartisan discussions about adding civil liberties and safeguards. Some members support them, some oppose them, but just about everyone agrees that this is serious stuff, the kind of debate that Congress ought to have in the open. Instead, Republican leadership just jammed us. Does anybody actually know what the hell is in this thing? It is 11:30 at night. The bill was changed just minutes ago, and they had to post a corrected version already. I mean, that is how sloppy all of this is. Now, let me be crystal clear to my colleagues across the aisle. This is too damn important to do it this way. Way too important. No hearings, no markups, no real process, no transparency, no time to read it, no time to vet it. And yet we are told that there are, quote, major reforms in this bill. No real explanation, no real accountability, basically no time for anybody to figure out what the hell is going on. And now we're all supposed to act like this is normal. Give me a break. We will have to live with this for 5 years. The American people have to live with this for 5 years. And Democrats, and quite frankly, a whole lot of Republicans too, have barely had enough time to read the text, let alone understand any of its implications. I bumped into a handful of Republicans on the way up here, and they asked me, what's going on? What changes have been made? What's in this bill? Your own members don't know what the hell you're doing. But this mess did not come out of nowhere. Republicans knew for months that the April 20th FISA deadline was coming. They knew they had a vote problem before the Easter recess. And instead of staying here and doing their jobs or spending the district work period trying to work it out, they kicked the can down the road and made this mess even worse. Now everybody can see the chaos. It's out in the open. I mean, they barely got a rule on a Rules Committee. I mean, three Republican members on the Rules Committee had to skip the vote just so the rule could be reported out. That's how divided this Republican conference is. I mean, Donald Trump had to jump in and tell Republicans to unify just to drag this thing forward. That is how pathetic this has all gotten. We are standing here more than 36 hours after we were supposed to debate this rule. 36 hours with a bill dumped on the House and the American public in the middle of the night as a deadline looms. I got to tell you, this is not leadership. This is not legislating. This is not governing. This is not a functioning majority. This is a disaster. This is incompetence. This is incompetence. And after all the chaos and all the delays and all the backroom dealing, we're still left with the same question. What the hell is going on here? This process is embarrassing. This majority is incompetent. And if this is how Republicans handle something as serious as national security surveillance, then they have no business being in charge. And with that, I reserve.
Gentleman reserves. Gentleman from Georgia is recognized.
Mr. Speaker, I want the American citizens to know we've had honest debate over the balance between security and the Fourth Amendment of the Constitution. And sometimes that debate takes a little longer than we wish it would. But I wish my colleagues on the other side of the aisle would read this document, the United States Constitution, just as we as Republicans read it and take it seriously. With that, I yield 2 minutes to the gentlelady from North Carolina, the chair of the Rules Committee.
Gentlelady from North Carolina is recognized.
Thank you, Mr. Chairman, and I thank my colleague from Georgia for yielding time, and I thank him for the yeoman's work that he does as a member of the Rules Committee the member of the Agriculture Committee, and a member of the Intelligence Committee. He knows what he is talking about here tonight because of the work that he has done over the years, particularly on the Intelligence Committee. Mr. Speaker, I don't think anybody in this country can deny that we are living in a very dangerous world. We are dealing with terrorism and narco-terrorism constantly. I want to compliment all the segments of our conference. You know, many people don't realize quite the range of ideas and talents that we have in the Republican Conference, and it does sometimes take us a while to consider all of the ideas that members have. But we have some very strong people in our conference whose reason for being here is to protect the American people. And it takes a while sometimes for the conference parts to come together to do what we are elected to do. Use the agencies of the federal government to protect the American people. The People's House is doing its job tonight by reauthorizing FISA 702 with the excellent reforms that my colleague has outlined. This is not incompetence. It's responsible legislating, Mr. Speaker. FISA 702 expires on Monday night, April 20th at 12:01. We must pass a reauthorization of that so it can go to the Senate and be passed by the Senate and signed by the President before it expires. We are doing our job, Mr. Speaker, as the People's House. And again, I commend my colleague from Georgia for the work that he's done, but all of my colleagues who came together to come up with a very, very good bill in this bill that we're going to pass later tonight. I urge everyone to vote for the rule and to vote for the underlying bill, and I yield back.
I reserve.
Gentleman reserves. Gentleman from Massachusetts recognized.
Mr. Speaker, with all due respect to the chairwoman of the Rules Committee, this process stinks. And she thanks all of her colleagues for coming together to trying to work out this deal. As far as I can tell, there's a handful of people, you know, in a back room somewhere who put this together. I mean, some of this has been is handwritten. This was not the result of everybody participating in a process, in an open and transparent process. This is a backroom deal. You know, it's 11:40, and people are going to see this for the very first time. You know, some of us, myself included, you know, was hoping that we would have a serious warrant requirement in Section 702. I mean, I talked to a lot of my very conservative Republican colleagues, and they agreed with me that that was something that they thought was important. And this so-called warrant requirement in this draft that you just gave us has nothing to do with Section 702. It is already the law that if the FBI has probable cause, they can go to court and seek a warrant. What we are trying to solve is a different problem. Section 702 takes in a massive amount of U.S. person information, and nothing in this bill stops the government from searching it or requires them to go to a judge. I mean, and again, the gentleman from Georgia, who the chairwoman says knows everything about everything, let me ask, I mean, is there anything new in this bill that requires a warrant to query U.S. persons in Section 702? That's a question. I'm happy to yield for an answer. Well, let me answer it, since I'm not getting an answer from the people in charge? The answer is no. The answer is no. So if anybody here is voting for this because they think that this issue has been resolved, please know it hasn't. And if you vote for it, you're a cheap date, because it doesn't solve the problem that we've had many discussions about. You know, we found this out in the 15 minutes that we had to read the text, because, again, we just got this bill. Who knows what else we'll find in a day or a week when experts have a chance to analyze it. Again, this is an important matter. The privacy of American citizens is an important matter. The national security of our country is an important matter. And you're just piecing this together, you know, in a couple of minutes and, you know, and saying, take it, trust us. You know, we just pieced this together in a back room, just take it. Well, we're not. This is a lousy process. This reflects the incompetence of the leadership of this House. It is a disgrace. I reserve my time.
Gentleman reserves. Gentleman from Georgia is recognized.
I reserve.
Gentleman from Georgia reserves. Gentleman from Massachusetts recognized.
I thought the gentleman was going to answer my question, but anyway, Mr. Speaker, I'm happy to yield 6 minutes to the gentleman from Maryland, the distinguished ranking member of the Committee on the Judiciary, Mr. Raskin.
Gentleman from Maryland is recognized.
Mr. Speaker, thank you very much, and please forgive me because I didn't even have 15 minutes to read it. I had to drive down from Maryland's beautiful 8th District, and so I've had about 90 seconds to review this product that we were supposed to have been working on for the last several months. But let me do my best to try to analyze for people what's happening, because already the machinery of propaganda and disinformation has set in, and people are talking about a magic warrant requirement which has appeared in here, which is complete and utter nonsense. But let me start by echoing the distinguished chairman of the Rules Committee. This is an appalling, Kafkaesque process leading to an absurd Orwellian result. This is much worse than what was being offered before of the clean 2-year reauthorization. The substance of this proposal is utterly appalling. They say you shouldn't look to see how the sausage gets made. This isn't even sausage. This is scrapple. It's scrapple with dog food mixed inside of it. Now, I'm going to have to try to read through it to understand what they're doing. But let's start with this. Originally, they proposed an 18-month clean reauthorization. And the Democrats and some members of the Freedom Caucus who were very skeptical of the enterprise said 18 months, that's not like any short-term extension we know around here. Usually we talk about 72 hours or a week or 2 weeks. 18 months, that's a huge, massive expansion. So then they went into some kind of compromise session with the White House. None of us were invited, so we don't know who was there or what was spoken. But they went from 18 months to 5 years. They went from a clean 2-year reauthorization to a 5-year dirty deal. And the saving grace of it is supposed to be a so-called warrant requirement, which I'll investigate in a second, which doesn't kick in for another 2 years. So we have 2 years without their illusory Band-Aid that they're putting on this process, this fake warrant requirement. So the Trump administration can do whatever they want, even without this mythical, inscrutable warrant requirement. And then we get 5 more years of this. And this is the compromise that they worked out behind our backs, and all we could rely on was the goodwill of the handful of members of the Freedom Caucus who were standing up for the Constitution and the civil liberties and civil rights of the people. So I don't think that our friends in the Freedom Caucus have done the American people any favor if they're signing off on this. All right, so the first thing that they do is they change the terms of the length of the legislation. A 5-year authorization with the fraudulent warrant requirement not kicking in for 2 years. All right, well, let's look at the much vaunted warrant requirement, which appears on page 3. Let's start with this in trying to understand the gobbledygook here. The FBI may not ingest unminimized information acquired under this section into its analytic repositories unless the targeted person is relevant to an existing, open, predicated, full national security investigation by the FBI. If the subject of such predicated full national security investigation is a U.S. person, for purposes of this paragraph, the investigation must be supported by probable cause. Okay, this is supposed to be the big concession to the people who are saying that the Constitution governs and the Fourth Amendment is still alive, right? Well, what's the first thing that I notice as someone who spent 25 years as a constitutional law professor? Well, the operative part of it is the last 8 words there. The investigation must be supported by probable cause. It doesn't say it's got to be supported by a search warrant. Much less does it say it's got to be supported by a search warrant or probable cause determined by a judge, by a court. That's not in there. So who's going to figure out whether it's supported by probable cause? And we're not talking about evidence of a crime. We're talking about a predicated national security investigation. Well, you flip the page, and you find out the Attorney General and the Director of National Intelligence shall jointly establish procedures and standards for officers and employees of the United States government to determine the existence of probable cause. Well, there goes the requirement, the constitutional requirement, of an independent magistrate issuing a warrant. The FBI will be the judge of its own warrant. In other words, we're right back to the problem that got us here in the first place. Right? Now, look above there. We are told, pursuant to subsection B, no officer or employee of the U.S. government may intentionally target for acquisition the communications of a U.S. person pursuant to an authorization issued under subsection A. Pursuant to other provisions of this act, in the Federal Rules of Criminal Procedure, the government may seek a warrant or other appropriate order supported by a probable cause showing to target for collection the communications of a U.S. person if there exists probable cause that the U.S. person is a foreign power, et cetera, et cetera. May. Suddenly we go from the Constitution's imposition of a mandatory requirement for a warrant, right? That no warrant shall issue but upon probable cause, and there must be a warrant for a search unless there's a specific exception to it. But this simply says they may seek a warrant. They don't have to. They may seek a warrant. In other words, this provision 2 is meaningless. It just returns us to exactly where we were. Thank you, Mr. McGovern. It takes us right back to the status quo. So, when it says that the Attorney General, that would be Kash Patel, oh no, that would be, forgive me, Todd Blanche, or the acting Attorney General, Todd Blanche, and the Director of D&I shall establish the procedures for determining if there's probable cause. Gee, I thought that James Madison and George Mason had taken care of that. I thought the Constitution established the meaning of probable cause. Now it's being delegated to the acting Attorney General. Actually, it doesn't even say the acting, but whoever the Attorney General might be. Perhaps acting is imported through this language. Who knows? Do we really want Pam Bondi or Kash Patel or Todd Blanche figuring out what our Fourth Amendment rights are, and then they get to decide for themselves without going to a court? At the very least, even if we're not going to have an actual warrant, there must be an independent judge, a magistrate involved in defining whether or not there's probable cause to search American citizens. That's the bottom line here. Everybody knows and understands our Constitution. And yes, our Constitution applies in peacetime, it applies in wartime. It applies to American citizens in America, it applies to American citizens abroad. And we're very willing to sit down to try to figure out some way we can deal with this thorny area of the law, but sneaky meetings at the White House behind everybody's back and then votes in 2:30 in the morning are not going to do it for the Constitution and the Bill of Rights of the American people. I thank you, Mr. McGovern. I yield back.
I reserve.
Gentleman reserves. Gentleman from Georgia is recognized.
Well, thank you, Mr. Speaker. And I know Mr. Raskin is a very good courtroom lawyer, and I mean that. And if I needed a lawyer, a defense lawyer, you would be one of the first I would hire. But I don't need a defense lawyer, thankfully. I do want to point out to you a couple of things that did not get mentioned. And this is on page 5. Any information concerning a United States person acquired under Section 702 may not be used in evidence against that United States person pursuant to paragraph 1 in any criminal proceedings if such information was acquired in violation of subsection O of such section. Now, when you go to subsection O, warrant requirement for certain targeting. No, it is not. It is not. It is not. You can debate that on your time. There are significant changes here. One of the other changes that they have not mentioned is that any query against a U.S. person by the FBI, and this is an accountability measure, a new accountability measure, must be reported to the Civil Liberties Protection Officer within the Office of the Director of National Intelligence. So any query that the FBI does on a United States person must be reported with the justification for the query, not to the Justice Department, but to the Civil Liberties Protection Officer within the Office of the Director of National Intelligence. Now, let me say this about 702. First of all, 702 is not a law enforcement tool. It is an intelligence tool. It is designed to protect Americans in this country from terrorists. That is what it is designed for. The FBI is actually prohibited from querying 702 data for evidence of a crime. It is an intelligence tool, not a criminal tool. The FBI can only access FISA 702 data if the Foreign Section 702 target is relevant to an existing, open, predicated, full national security investigation. We are talking about terrorism and narco-terrorism. With that, Mr. Speaker, I look forward to the continued discussion on the rule. I want to thank my colleague, the chair of the Intelligence Committee, Rick Crawford, for the work that he has done on it. Many people on our side have worked diligently to accommodate people and to make sure that we are doing the things that we need to do to protect Americans and to protect their civil liberties. And with that, Mr. Speaker, I reserve.
Gentleman reserves. Gentleman from Massachusetts recognized.
Mr. Speaker, this is also damn frustrating because basically what the gentleman has done is kind of restated current law. And what he's, what the big reform that he's bragging about is that the administration has to report something to the administration. I mean, give me a break. I yield 90 seconds to Mr. Raskin.
Gentleman from Maryland's recognized.
Thank you, Mr. Speaker. And I want to thank the distinguished gentleman from Georgia for his points. But I hope that their entire case doesn't rest on the argument that he just advanced from page 5. And he quoted the section saying, any information concerning a U.S. person acquired under 702 may not be used in evidence against that person in any criminal proceeding if such information was acquired in violation of subsection O. And if you go to O, it says, pursuant to subsection B, no officer or employee of the government may intentionally target for acquisition the communications of U.S. person. That's precisely the law today. This is a restatement of what is already the law. FISA it's called the Foreign Intelligence Surveillance Act. It's all about the surveillance of people abroad. It's not about surveilling people here. If somebody were deliberately targeted, every judge in the land, even those most faithfully reporting to Donald Trump would say, I'm sorry, you can't target U.S. citizens on that under FISA. This is all about the collection of incidental data. I thought that was, and everybody understood that was the premise of our whole legislative discussion here. This is about the collection of incidental data affecting thousands, hundreds of thousands of American citizens. That's what we're talking about. So the passage that you just read is a restatement of what the law is today, which is if they set out to go after American citizens here, of course the exclusionary rule operates at that point. It will be prohibited. The question is what happens if they incidentally collected, and under this new language, nothing happens unless somebody permissively decides they want to adopt a rule over at the Department of Justice, making it a problem. I yield back.
Reserve.
Gentleman reserves. Gentleman from Georgia is recognized.
Mr. Speaker, 702 is an intelligence tool that has been reauthorized in a bipartisan manner under both Democrat and Republican administrations. It is an intelligence tool that my colleagues on both sides of the aisle know must be reauthorized to protect the citizens of the United States of America. This bill coming before us today has additional protections over and above the 56 protections that we adopted, again in a bipartisan manner, in the FISA legislation just a few years ago. Mr. Speaker, I look forward to the passage of this rule. I look forward to the passage of the legislation. People on our side have worked in good faith to make sure that we do anything and everything that we can to protect the United States citizens without violating their constitutional rights. That is why the additional provisions have been added in here. And I again want to go back to this provision that I read to you, where if any information is obtained against a U.S. person, none of that information can be used to prosecute a U.S. person unless a warrant had been obtained first. 702 is not a law enforcement tool. It is an intelligence tool. It is an intelligence tool that has been properly designed to protect the United States and its citizens from people who want to destroy us. With that, Mr. Speaker, I reserve.
Gentleman reserves. Gentleman from Massachusetts recognized.
Mr. Speaker, can I inquire of the gentleman how many other people on his side want to restate current law?
We're prepared to close.
All right. Then I will yield myself the remaining time, Mr. Speaker.
Gentleman's recognized.
Mr. Speaker, it is no accident that at midnight we're debating this. This is intentional. Again, this bill was kind of pieced together in a back room somewhere here in the Capitol building with a handful of people, and here we are, and no one knows what the hell's in it. I mean, the gentleman from Georgia is basically reading talking points that, quite frankly, are a restatement of current law that don't address any of the issues that many of us had with this legislation, that we were trying to work out in a bipartisan way. And, we've been debating some of these issues for years. And when the gentleman says that his side has been working in good faith with us, this is good faith. We just got the text of this, minutes ago. And we're told, we'll be on the floor at 11:30 and let's begin this debate, with major changes in the text. I mean, that's good faith. Boy, you and I have a different idea of what good faith is. I think good faith was some of the conversations that were ongoing leading up to this moment. And you just toss that out the window like it doesn't matter. I mean, again, this process stinks. This is not the way you should be bringing important legislation to the floor. And let me just say to my friends in the Freedom Caucus, I disagree with you on most things, but every once in a while, we find areas of agreement, oftentimes on issues of privacy protection and protecting and upholding civil liberties. And I appreciate when we can come together on that. And I thought that that's what we were doing. That's what we were trying to get to.
Note they're not here defending.
But I'm looking for some of my Freedom Caucus friends to defend this. So maybe there's something here that I don't see. But they're not here defending this. But the bottom line is there is nothing new in here to protect people in Section 702. There's no warrant requirement that you need to go to get a warrant from a judge in Section 702. That's what we were asking for. That's what we were fighting for. That is not in this. So don't try to sell a bill of goods that somehow this legislation does something it does not. It fails in that regard. It fails in that regard. And so you control everything. So you can bring bills up at midnight and have these debates and say whatever you want to say. But boy, you should be ashamed of this process. Again, this is not a sense of Congress resolution. This is an important matter. You know, it's important not just for our national security. It is important for the protection of the privacy of American citizens, to make sure that information gathered on them is not misused. Yeah, and unfortunately, most of the American public at this point is asleep, so they're not even paying attention to any of the things that we're saying here today, because again, it's midnight when you're bringing this up. So I will just close by saying, this is a lousy way to run a Congress. My friends on the other side of the aisle who are trying to defend the indefensible, quite frankly, should be ashamed of themselves. People should vote against this rule, certainly. This is not the way we should bring legislation to the floor, and they should vote against the underlying bill. Every time I think I can't get more disappointed with the way Republicans are running this place, you come out with something like this. Again, the gall and the incompetence is stunning. And again, shame on my Republican friends. And with that, I yield back my time.